Question 1. Under the Uniform Securities Act, USA, which of the following is not included in the definition of a person? A. An individual. B. A corporation. C. A minor. D. A government or political subdivision. Answer: C. A minor. Under the Uniform Securities Act, the term person is broadly defined to include any individual, corporation, partnership, association, joint stock company, trust, unincorporated organization, or government. The key takeaway is that a minor, while an individual, is typically not considered a person for legal and contractual purposes in the context of the USA, as they lack the legal capacity to enter into binding agreements. Therefore, while a person generally refers to a legal entity capable of entering into contracts, a minor does not fit this specific legal definition within the USA framework. Remember that person is a very broad term on the exam, encompassing almost any legal entity, except for specific exclusions like minors. Question 2. An investment advisor registered under the Uniform Securities Act must renew its registration. A. Annually, on December 31st. B. Every 2 years from the initial registration date. C. Annually, on the anniversary of its initial registration. D. Every 5 years, regardless of the initial registration date. Answer: A. Annually, on December 31st. Under the Uniform Securities Act, the registration of investment advisors, broker-dealers, and agents typically expires annually on December 31st, regardless of when their initial registration became effective. This standardized renewal date helps the administrator manage all registrations consistently at year-end. For example, if an investment advisor registers in August, their first renewal would still be due by December 31st of that same year. It's crucial to remember this specific annual renewal date for all state-registered entities and individuals. Question 3. Under the Uniform Securities Act, USA, which of the following is considered an unlawful practice for an investment advisor? A. Charging a fee based on the total assets under management. B. Exercising discretion in a client's account without written authorization. C. Providing investment advice to a client based on their risk tolerance. D. Disclosing potential conflicts of interest to clients. Answer: B. Exercising discretion in a client's account without written authorization. An investment advisor or an investment advisor representative acts in a fiduciary capacity, requiring them to prioritize the client's best interests. Exercising discretionary authority, which means making investment decisions like security, amount, or action without specific client instruction for each trade, is a serious breach of trust and a prohibited practice unless the advisor has obtained prior written authorization from the client. For example, if an advisor decides to buy 100 shares of XYZ stock for a client without direct permission for that specific trade, it is unlawful unless written discretionary authority is already on file. Always remember that written authorization is almost always required for discretionary trading to protect both the client and the advisor. Question 4. An agent's registration under the Uniform Securities Act, USA, becomes effective. A. On the date the application is filed with the administrator. B. 30 days after the application is filed, if no stop order is in effect. C. On the date the administrator approves the application. D. 10 days after the application is filed, if no stop order is in effect. Answer: B. 30 days after the application is filed, if no stop order is in effect. Under the Uniform Securities Act, the registration of broker-dealers, agents, investment advisors, and investment advisor representatives typically becomes effective automatically at noon on the 30th day after the application is filed, provided the administrator has not issued a stop order or initiated a proceeding. This 30-day rule is a crucial aspect of the registration process, indicating a default approval if no issues are identified. For instance, if an agent files their complete application on January 1st, their registration would become effective on January 31st unless the administrator intervened. Always associate the 30-day mark with the automatic effectiveness of registrations. Question 5. Which of the following statements regarding the administrator's jurisdiction under the Uniform Securities Act, USA, is true? A. The administrator only has jurisdiction if the offer originated in the state. B. The administrator only has jurisdiction if the offer was accepted in the state. C. The administrator has jurisdiction if an offer to buy or sell is made in the state or directed to and received in the state. D. The administrator has jurisdiction only if both the offer originated and was accepted in the state. Answer: C. The administrator has jurisdiction if an offer to buy or sell is made in the state or directed to and received in the state. The Uniform Securities Act grants the administrator broad jurisdiction over securities transactions. Jurisdiction applies if an offer to buy or sell is made in the state, originated from the state, or is directed to and received in the state, even if no sale occurs. This two-pronged rule ensures comprehensive oversight, meaning that if a solicitation for a security originates from State A and is received by an investor in State B, both State A and State B administrators have jurisdiction. Understanding this jurisdictional reach is vital for compliance, as it means multiple state administrators might have authority over a single transaction. Question 6. A security is exempt from registration under the Uniform Securities Act, USA, if it is issued by A. A private limited liability company. B. A non-profit charitable organization. C. The U.S. government or any state or political subdivision thereof. D. A small business corporation. Answer: C. The U.S. government or any state or political subdivision thereof. Securities issued or guaranteed by the U.S. government, any state, or any political subdivision of a state, like a municipality, are considered exempt securities under the Uniform Securities Act. This exemption reflects the belief that these issuers are inherently trustworthy and their securities have minimal risk of default, making extensive registration unnecessary. For example, Treasury bonds, municipal bonds, and state-issued general obligation bonds are all exempt from state registration requirements. Memorizing these government-backed exemptions is a crucial step for the Series 63 exam. Question 7. What is the maximum criminal penalty for a violation of the Uniform Securities Act, unless state law specifies a greater penalty? A. $10,000 fine and/or 5 years imprisonment. B. $5,000 fine and/or 3 years imprisonment. C. $25,000 fine and/or 10 years imprisonment. D. $1,000 fine and/or 1 year imprisonment. Answer: B. $5,000 fine and/or 3 years imprisonment. Under the Uniform Securities Act, the maximum criminal penalty for a person who willfully violates any provision of the Act is a fine of $5,000 and/or imprisonment for 3 years, unless state law provides for a greater penalty. It's important to note that this applies to willful violations, meaning the person acted intentionally and knew they were violating the law. For example, if an unregistered individual knowingly sells non-exempt securities, they could face these penalties. This specific monetary and time penalty is a common, must-memorize, item for the exam. Question 8. Under the Uniform Securities Act, USA, a broker-dealer's registration may be cancelled by the administrator if the firm A. Has too many clients. B. Is insolvent. C. Has low trading volume. D. Is operating at a loss for a single quarter. Answer: B. Is insolvent. The administrator has the power to cancel a registration, which is a non-punitive action, if the registrant no longer exists or has ceased to engage in the securities business. Insolvency, meaning the firm is financially unable to meet its obligations, is a specific condition under the USA that allows the administrator to cancel a broker-dealer's registration. For example, if a broker-dealer declares bankruptcy, the administrator would likely cancel its registration to protect the public. Remember that cancellation is different from a suspension or revocation, as it implies a lack of qualification or existence rather than a punitive measure for misconduct. Question 9. An individual who represents an issuer in the sale of that issuer's securities to the public is generally defined as an A. Investment advisor. B. Broker-dealer. C. Agent. D. Investment advisor representative. Answer: C. Agent. An agent is defined under the Uniform Securities Act as any individual who represents a broker-dealer or an issuer in effecting or attempting to effect purchases or sales of securities. When an individual represents an issuer, the company itself, in selling its own securities, they are typically considered an agent, unless a specific exemption applies, example selling only to existing employees without compensation. For example, a company employee who sells shares of their employer's stock directly to the public would be an agent. It's essential to distinguish between representing a broker-dealer versus an issuer when identifying an agent. Question 10. Under the Uniform Securities Act, USA, which of the following is not considered a security? A. Common stock. B. A fixed annuity contract. C. A variable annuity contract. D. An investment contract. Answer: B. A fixed annuity contract. The Uniform Securities Act broadly defines security to include most common investment products, but specifically excludes certain insurance products and commodities. A fixed annuity contract is typically considered an insurance product, as its payout is guaranteed by the insurance company and does not carry investment risk for the principal. In contrast, a variable annuity, which has a separate account and involves investment risk, is considered a security. Remember that anything guaranteeing a fixed return or principal is typically not a security, such as a fixed annuity or a traditional life insurance policy. Question 11. What is the statute of limitations for civil liabilities under the Uniform Securities Act? A. 1 year from discovery of the violation, or 3 years from the date of the violation, whichever comes first. B. 2 years from discovery of the violation, or 5 years from the date of the violation, whichever comes first. C. 3 years from discovery of the violation, or 7 years from the date of the violation, whichever comes first. D. 5 years from the date of the violation, regardless of discovery. Answer: A. 1 year from discovery of the violation, or 3 years from the date of the violation, whichever comes first. Under the Uniform Securities Act, a client must bring a civil lawsuit for a securities violation within the specified statute of limitations. This limit is 1 year after the discovery of the violation or 3 years after the date of the violation, whichever occurs first. This dual timeline ensures that claims are brought promptly once the fraud or violation is known, but also sets an ultimate cutoff date for liability. For example, if a client discovers a violation 2.5 years after it happened, they have 6 months to file. If they discover it 3.5 years after, they are out of time. Always remember the 1 and 3 rule for civil liability. Question 12. A broker-dealer must maintain records for how many years under the Uniform Securities Act? A. 3 years. B. 5 years. C. 6 years. D. 10 years. Answer: A. 3 years. Under the Uniform Securities Act, broker-dealers are generally required to maintain records for 3 years, with the most recent 2 years readily accessible in an appropriate office. This record-keeping requirement allows regulators to review a firm's activities and ensure compliance with securities laws. For example, trade confirmations, account statements, and correspondence must be kept for this period. While FINRA rules typically require 6 years for certain records, the USA's default is 3 years, so pay attention to the specific act being referenced. Question 13. Which of the following is an example of an exempt transaction under the Uniform Securities Act? A. A public offering of common stock by a new company. B. An unsolicited non-issuer transaction. C. A recommendation made by an unregistered agent. D. An initial public offering, IPO, of a large corporation. Answer, B. An unsolicited non-issuer transaction. An unsolicited non-issuer transaction is an exempt transaction under the Uniform Securities Act, meaning it is exempt from the registration requirements for the security and the transaction itself. Unsolicited means the client initiated the trade without any recommendation or solicitation from the broker-dealer, and non-issuer means the transaction is between investors, not involving the original issuer. For example, if a client calls their broker and requests to buy shares of a stock they researched independently, that transaction is exempt. Always remember that unsolicited client orders are generally exempt because no marketing or solicitation from the firm triggered the trade. Question 14. An investment advisor who only provides advice regarding U.S. government securities. A. Is exempt from registration as an investment advisor under state law. B. Must register as an investment advisor at the state level. C. Must register as a federal covered investment advisor. D. Is exempt from registration as an investment advisor under federal law. Answer, A. Is exempt from registration as an investment advisor under state law. Under the Uniform Securities Act, an investment advisor whose sole business is providing advice regarding U.S. government securities is exempt from state registration. This exemption is based on the perceived low risk of these securities and the federal government's backing. For instance, a firm that only advises on treasury bonds would not need to register with the state administrator. This is a specific and important exemption to remember, as it applies even if the advisor otherwise meets the definition of an investment advisor. Question 15. The administrator has the authority to issue a cease and desist order against a person who is A. Not registered in the state. B. About to violate the Uniform Securities Act. C. Suspected of violating the Uniform Securities Act. D. Engaged in or about to engage in a violation of the Uniform Securities Act. Answer, D. Engaged in or about to engage in a violation of the Uniform Securities Act. A cease and desist order is a powerful tool the administrator can use to prevent ongoing or imminent violations of the Uniform Securities Act. This order requires a person to stop performing an action that the administrator believes is illegal or about to become illegal. For example, if an administrator discovers an unregistered individual selling securities, they can issue a cease and desist order to immediately halt that activity. Understanding that this power extends to both current and impending violations is key. Question 16. A consent to service of process, filed with the administrator, means A. The applicant agrees to all rules and regulations of the state. B. The administrator can receive legal papers on behalf of the registrant. C. The applicant consents to criminal background checks. D. The administrator agrees to provide legal assistance to the registrant. Answer, B. The administrator can receive legal papers on behalf of the registrant. When an applicant files a consent to service of process with their registration application, they are essentially appointing the state administrator as their attorney for receipt of legal papers. This means that if a client or regulatory body needs to serve a subpoena, complaint, or other legal document related to the registrant's securities activities in that state, they can serve it directly to the administrator, which is considered valid service on the registrant. This ensures that registrants, even if they leave the state, can still be held accountable for actions performed while registered in that state. Question 17. Under the Uniform Securities Act, an investment advisor is considered federal covered if they A. Have at least $25 million in assets under management, AUM. B. Advise an investment company registered under the Investment Company Act of 1940. C. Provide advice to residents of only one state. D. Are registered with a state administrator. Answer, B. Advise an investment company registered under the Investment Company Act of 1940. One of the primary criteria for being a federal covered investment advisor under the Uniform Securities Act and the National Securities Markets Improvement Act of 1996 is providing advice to a registered investment company, such as a mutual fund. Federal covered advisors register with the SEC, not state administrators. Another common threshold for federal coverage is having $110 million or more in assets under management. Knowing the specific conditions that make an advisor federal covered is crucial because it determines whether they register with the SEC or state authorities. Question 18. An administrator may require an applicant for registration to publish an announcement of the application in one or more newspapers of general circulation in the state. This is known as A. A public notice requirement. B. A bond posting. C. An escrow agreement. D. A disciplinary action. Answer: A. A public notice requirement. The Uniform Securities Act allows the administrator to require an applicant for registration, such as a broker-dealer or investment advisor, to publish an announcement of their application in a newspaper of general circulation. This public notice requirement serves to inform the public and potentially solicit any objections or relevant information about the applicant before registration becomes effective. It's a method for enhancing transparency and public protection in the registration process. Question 19. If an investment advisor has custody of client funds or securities, the administrator may require A. The advisor to maintain a minimum net worth. B. The advisor to submit to an annual surprise audit. C. The advisor to post a bond. D. All of the above. Answer: D. All of the above. When an investment advisor takes custody of client funds or securities, the administrator imposes stricter requirements to protect those assets. These measures can include requiring the advisor to maintain a minimum net worth to demonstrate financial solvency, submitting to an annual surprise audit by an independent accountant to verify assets, and posting a bond to provide financial protection against misconduct. All these are permissible actions by the administrator to safeguard client assets. Remember that taking custody triggers additional and significant regulatory requirements. Question 20. Under the Uniform Securities Act, the term offer or offer to sell does not include A. A security given as a bonus for buying another security. B. A gift of assessable stock. C. A bona fide pledge or loan of a security. D. An attempt to dispose of a security for value. Answer: C. A bona fide pledge or loan of a security. The Uniform Securities Act defines offer or offer to sell very broadly to include any attempt or solicitation to dispose of a security or interest in a security for value. However, certain actions are specifically excluded from this definition. A bona fide pledge or loan of a security, where the security is merely collateral for a loan and not being actively sold, is not considered an offer or sale. For example, if you use your stock as collateral for a bank loan, that action is not an offer to sell the stock. Understanding these specific exclusions is important for regulatory compliance. Question 21. If an agent terminates employment with a broker-dealer, who is responsible for notifying the administrator? A. Only the agent. B. Only the broker-dealer. C. Both the agent and the broker-dealer. D. The administrator automatically knows through FINRA. Answer: C. Both the agent and the broker-dealer. When an agent's employment with a broker-dealer terminates, both parties have a responsibility to promptly notify the administrator. This dual notification requirement ensures that the administrator is immediately aware of the change in the agent's registration status and can update their records accordingly. For example, if an agent resigns from Firm A to join Firm B, both the agent and Firm A must inform the administrator, and then Firm B must register the agent. This both notify rule is a key administrative detail for agent registration. Question 22. Which of the following forms of compensation for an agent is generally prohibited under the Uniform Securities Act? A. Commissions based on sales. B. Fixed salary. C. Performance-based fees. D. Sharing in the profits or losses of a client's account. Answer: D. sharing in the profits or losses of a client's account. Sharing in the profits or losses of a client's account is a prohibited practice for agents and broker-dealers unless specific conditions are met, such as having a joint account with the client and receiving prior written authorization from the client and the firm, and only then in proportion to the agent's capital contribution. This rule prevents conflicts of interest and ensures the agent is not unduly incentivized by the client's investment performance beyond standard commissions or salary. For example, an agent cannot agree to take 10% of a client's profits on a stock trade without meeting the strict proportional ownership rules. Question 23. An administrator may require an investment advisor to furnish a bond if the advisor A. is a sole proprietor, B. charges advisory fees, C. has discretionary authority over client funds or securities, D. provides financial planning services. Answer: C. has discretionary authority over client funds or securities. The administrator can require an investment advisor to post a bond primarily when the advisor has discretionary authority over client accounts or takes custody of client funds or securities. A bond serves as financial protection for clients against potential losses due to the advisor's negligence, fraud, or misconduct. For instance, if an advisor can trade in a client's account without prior specific approval for each trade, a bond helps ensure the client is protected if the advisor causes losses through improper actions. This requirement is a protective measure tied to the level of control an advisor has over client assets. Question 24. Under the Uniform Securities Act, advertising and sales literature distributed by a broker-dealer must be filed with the administrator. A. At least 10 days before use. B. Only if specifically requested by the administrator. C. At the same time it is distributed. D. Annually, along with renewal applications. Answer: B. Only if specifically requested by the administrator. The Uniform Securities Act generally does not require broker-dealers or investment advisors to file advertising and sales literature with the administrator prior to use, or even upon use, unless specifically requested. The administrator has the authority to require the filing of any advertisement or sales literature, but this is usually a discretionary power exercised when there's a concern or during an examination. For example, a state administrator might ask a firm to submit all its marketing materials for review if a complaint has been lodged. This flexibility differs from FINRA rules, which often require pre-filing for certain types of communications. Question 25. Which of the following would not be considered a prohibited manipulative practice under the Uniform Securities Act? A. Creating a false appearance of active trading in a security. B. Spreading false rumors to influence a stock's price. C. Executing trades to establish a legitimate liquid market for a new issue. D. Engaging in wash sales, simultaneously buying and selling the same security to create artificial volume. Answer: C. Executing trades to establish a legitimate liquid market for a new issue. The Uniform Securities Act prohibits manipulative practices that artificially influence the price or volume of securities. Creating a false appearance of trading, spreading false rumors, or engaging in wash sales are all examples of such prohibited actions. However, executing legitimate trades to establish a fair and liquid market for a new issue, often referred to as stabilization, is a permissible and necessary practice under certain conditions, as long as it's not done with deceptive intent. This highlights the difference between genuine market-making activity and deceptive manipulation.